Okay, good afternoon, everyone. This is Claudia Center, and I welcome you to the LAC DREDF training on disability rights for California tenants and shelter residents. Next slide. I am thrilled to introduce you to our esteemed panelists, starting with Michelle Uzzetta, who is of counsel to DREDF, our newest to us lawyer. Many of you know Michelle. She's specialized in civil rights law since '93 with a particular emphasis on disability rights and fair housing litigation under the ADA, Section 504, Fair Housing Act, and related state laws. She has years of experience and a wonderful resume. You can read more about Michelle on the dredf.org website. We are thrilled that she is working with us. We also have Emily Rose Johns with us today, who is a senior associate with the Oakland-based civil rights firm Siegel, Yee, Bruner, and Mehta. We are thrilled to have Emily Rose Johns with us because she has been an active leader in litigation about disability rights in the context of unhoused or homeless people in the Bay Area, and has some recent cases that she's going to share with us. And you can read more about Emily Rose's illustrative background at the siegelyee.com website, SIEGELYEE.com website. And finally, you have me, Claudia Center. I'm the legal director with Disability Rights Education and Defense Fund, and I'm very glad to be here. Next slide. So I wanted to let you know the topics we're going to cover today. First, I am going to run us through a very brief overview of disability rights in housing, just to give us an orientation. And then I'm going to pass the floor over to Michelle Uzzetta, who's going to review some recent important case law in the area of disability rights and housing law. Where Michelle will then give some updates on the DFEH. And then we'll turn it over to Emily Rose, who will do a highlight on two of her cases, Where Do We Go Berkeley versus Caltrans, and Reed versus City of Emeryville. Then we'll have a short section on disability rights in new COVID-related housing, such as Project Home Key, Project Room Key. And then we'll have questions and answers. Next slide. Okay, brief overview of disability rights in housing. Next slide. Okay, I just want to review for everyone the core rights under state and federal laws that we have in disability rights. And we have some comments in the chat about access issues, but I will just keep talking. So a core right under the ADA, to the extent it applies to housing, under the Fair Housing Amendments Act, under Section 504 for federally funded housing, and under state laws that apply to housing. These are the core rights. First of all, no disability discrimination, that's pretty obvious, and no retaliation based on protected activity. So no discrimination includes no garden variety intentional discrimination, like we don't want to rent to disabled people, but it also includes no policies or practices that screen out disabled tenants. And this has been referred to as disparate impact discrimination, even though the regulations don't use that lingo. And, you know, disparate impact discrimination theories are sort of under attack from conservative judges and possibly our Supreme Court. So the disparate impact regulations for the Fair Housing Amendments Act were upheld in 2015 by the Supreme Court, but the Supreme Court has changed since then. So it's still a very fraught and important issue for disability rights. The second big right under our disability rights laws is the right to reasonable accommodation. We have a series of Ninth Circuit cases on reasonable accommodation, and two strong ones from 2003 and 2004, and a more recent one that Michelle is going to talk about today. Those are about the right to accommodations around financial screening for tenancy, and the right for extensions of time around tenancy. That's Giebler and McGarry. A next right under housing law is the right to make reasonable changes to your property at your own expense. And Michelle's going to talk about a case that relates to the difference between reasonable accommodation versus the right to make reasonable changes at your own expense. Next slide. There's a couple notes I'd like to add. If your housing defendant or respondent is covered by Title II of the ADA or Section 504, those laws have some stronger aspects to them compared to Fair Housing Amendments Act or Title III of the ADA by themselves. And that includes an obligation to provide program and architectural access. So just note that there's some stronger rights there, as well as communication access. And federally funded housing, proportions of units must have specifically delineated accessibility features. Two more notes. I talked about income screens with the Giebler case. There's also another recent case from 2020 called Riley from the California Supreme Court that talks about how income must be calculated for Section 8 housing. So you might want to look at that. And for accessing disability rights in state court, including in eviction proceedings, you'll want to look at Rule 1.100 under the California Rules of Court. And we also have a PowerPoint on that topic on the DREDF website. Next slide. I just wanted to quickly note that disability rights litigation has been brought on behalf of shelter residents, vehicle residents, and unhoused people under the ADA and Section 504. And these claims are often paired with constitutional claims, such as the claims brought in the Martin versus City of Boise case. And that's a Ninth Circuit case decided 2019. There's a Glover settlement from a couple of years ago, and you can see that the changes achieved under Section 504 and the ADA were relatively modest. There was not established under that litigation a right to housing. Disability rights tends to provide modifications and equal access, but it's difficult to create entitlements under those laws to housing, despite our best efforts. Next slide. And there are a couple of other cases, and these cases were led by primarily Disability Rights California. Glover was ACLU of Southern California. Some other cases brought against the City of San Diego and the County of Sonoma. City of San Diego, there was the plaintiffs were found to state a claim under disability rights laws that an ordinance prohibiting sleeping in your vehicle had a disparate impact on disabled people who were unable to access shelters. And so that was a big victory. And the Vanucci case against the County of Sonoma required notice and an offer of adequate shelter before moving people along from outdoor dwellings on the streets and sidewalks. Next slide. Okay, that was a whirlwind, but I promised I would only go for 10 minutes, and I'm going to turn it over to Michelle now.
Hi, everybody. This is Michelle Uzetta. I have been asked to give an overview of some cases from the last 18 months to 24 months that are of interest to people who are representing tenants with disabilities. There's about 10 cases that I'm going to give a bird's eye view of today. And I want to preface this by saying none of the cases are DREDF cases. So a lot of them were brought by either private counsel or a lot of the legal services folks in the state. Can't see the participants on the call, but I assume many of you who've worked on some of these cases are there. And I encourage you to jump in the chat and, give yourself a pat on the back if it's your case. The 10 cases I'm giving an overview of are a combination of good law and bad law. But I would encourage everyone on today's presentation to pull them up and take a look because they are very interesting. So there's one case that I wanted to address that has to do with who's protected by the Fair Housing Act. The case is Salisbury versus City of Santa Monica. This case involved an individual with a disability who sued the City of Santa Monica, alleging that the city violated the Fair Housing Act when it failed to grant his request for parking accommodations at a city-owned mobile home park where he had resided for many, many years, both with his elderly father and then on his own after his father passed away. In the case, the district court granted summary judgment to the city after concluding that under California law, the plaintiff wasn't authorized to reside in the mobile home park. It was undisputed in the case, as far as I know, that the plaintiff never had a lease in his own name at the property. He was never on a lease, and he'd never paid any sort of rent or other compensation to reside at the premises. And the court, although the plaintiff's attorneys did make the argument that the plaintiff's presence at the property had created an implied tenancy or a tenancy at will under California law, the federal court did not find that argument compelling. So the plaintiff appealed, it went up to the Ninth Circuit. The question presented on appeal was whether the Fair Housing Act requires a landlord to accommodate the disability of an individual when the individual had not entered into a lease nor paid rent in exchange for the right to occupy the premises. The panel affirmed the district court decision in the case, holding that the Fair Housing Act applies to rentals only when the rental arrangement is supported by adequate compensation or consideration, and they did not find that the facts supported that here. The panel relied heavily on the Act's language, talking about rentals and sales of dwellings to buyers or tenants, and found that a rental for purposes of the Fair Housing Act only exists where the landlord or a designee has received consideration. There were some bad facts in the case noted by the panel. I had mentioned earlier, the plaintiff was not on a lease, nor was he denied the ability to enter into a lease. And prior to the father's death, the father had certified on more than one occasion that he lived in the mobile home alone. The next couple of cases deal with reasonable accommodation and modification requests. The first one, Claudia mentioned briefly, Howard versus HMK Holdings. In that case, the Howards are a married couple. They rented a home in Los Angeles from HMK. They did not respond to some requests to re-enter a lease for their rental housing and subsequently received a 60-day notice to quit. They requested a 2-month extension of their lease termination as an accommodation for the husband who had medical conditions, including a significant brain injury, and he also experienced seizures. The Howards wanted to move cross country, but the husband's neurologist had confirmed that he was unable to safely embark on a long trip until his medical conditions stabilized. So that was the basis for the accommodation request of the couple. HMK granted one extension, but then denied a follow-up extension request for more time, claiming that the request was just too open-ended. So the Howards filed suit alleging both a failure to accommodate and a failure to engage in an interactive process regarding the Howards' accommodation needs. The district court granted summary judgment for HMK. They concluded that the Howards had failed to show that extending the tenancy was necessary, and also held that the FHA does not, or the Fair Housing Act does not impose independent liability for a failure to engage in an interactive process regarding accommodation requests. Case went up to the Ninth Circuit. Unfortunately, the Ninth Circuit affirmed the district court decision. They concluded that there was no nexus between the accommodation that was requested and the Howard's use and enjoyment of their dwelling. And they really focused on the fact that the neurologist in the case, who had offered a letter of support for the accommodation, had stressed how a long distance move would have been trying for the husband, and didn't address whether, moving down the block temporarily would be difficult. And the panel found that there was no evidence that relocating the husband to another residence in Los Angeles while his condition stabilized would have jeopardized his health. The court also rejected the argument that the Fair Housing Act imposes a standalone liability for the failure to engage in an interactive process. And this is actually the first time that the Ninth Circuit has addressed whether or not an interactive process is necessary in a standalone claim under the Fair Housing Act. The panel focused on the text and regulations of the act, which do not mention an interactive process in the same way that some other laws do in the employment setting. So there's two takeaways from the case that I wanted to stress. I mean, I encourage everybody to read it if you haven't already. It's a particularly harsh ruling, particularly when you consider the balance of hardships between the parties. I mean, the Howards were continuing to pay rent at a slightly higher amount. And the panel really seemed to go out of its way to find that there was no necessity or nexus between the accommodation request and what these folks needed to use and enjoy their housing. And the characterization of, the panel felt that this family could just move. It really ignored, I guess, the physical trauma that people with disabilities experience when having to relocate, even on a temporary or short-term basis. This individual was not going to be able to move safely, and it's unfortunate that the panel did not view that. The second point was with regard to the interactive process. A lot of defendants are now citing this case, claiming that there's no obligation to engage in an interactive process at all. And although engaging in an interactive process, the failure to do so may not be a standalone claim under the Fair Housing Act, the failure to engage in an interactive process is still considered when a court is assessing whether or not a landlord or a housing provider has failed to grant an accommodation. So there are two cases and the joint statement that I mentioned in the slide that can be cited for the proposition that it's still a relevant consideration whether or not the landlord engaged in an interactive process or not. The next case is a case that I litigated and it just went sideways on all issues. So I'm considering appeal. It's a case involving an applicant for housing who uses an emotional support animal. And she and her roommate submitted an application, and listed on the application, we have one registered support dog. And the landlord responded in writing in an email saying, "It's my policy not to accept dogs, even if service dogs," and followed that up with a question, "What is the weight of the dog?" which is not an acceptable question when you're dealing with emotional support dogs or service dogs. The plaintiff's roommate, then she was like the main contact with the proposed landlord, and she engaged in a couple of back and forth emails where she stated on multiple occasions that the dog was a support dog for emotional support, that it was covered by federal anti-discrimination laws, and that it was illegal to discriminate against somebody based on the use of a support or service dog. After the roommate mentioned that it was discrimination, the landlord ceased communicating with the potential tenants, and within 45 minutes or so returned their application fee. So the plaintiff sued, alleging a failure to accommodate and also discriminatory statements based on the landlord's statement that it was their policy not to accept dogs, even if service dogs. Despite what I thought were pretty good facts, summary judgment was entered in the landlord's favor on the failure to accommodate claim a couple months ago, and that's the citation at the top of this slide. The court found that the plaintiff could not establish that the landlord knew or should have known that she was disabled, despite the fact that the rental application listed a support dog, despite the fact that the landlord responded with, the disclaimer that I don't even accept service dogs, which would suggest to me that he knew someone with a disability was in the two-person household. The fact that the content of the roommates' emails talked about emotional support dogs, mentioned reasonable accommodations, mentioned the ADA, although the ADA did not apply to this particular housing provider, but disability was there, in the discussions. And this was also a housing provider who was a physician, who had some familiarity with emotional support dogs, who had familiarity with the ADA, and had been renting housing for approximately 40 years. So the court ignored all that and focused on the fact that the plaintiff did not expressly tell the landlord that she had a disability. The court did not make any it didn't distinguish at all between actual knowledge and another way of proving discrimination, which is that they should have known about the disability. He treated both the should have known or did know as both requiring actual knowledge and actual communication from the tenant. The court also ignored the landlord's failure to engage in an interactive process, even to consider that when looking at the reasonable accommodation claim. Really surprising that summary judgment was based on despite all of that evidence, because in my opinion, a reasonable jury could have found that this landlord should have known that the person applying for the housing had a disability. On the second claim, the discriminatory statement claim, that went to trial, and it was a trial on the briefs for strategic reasons. And the court, again, found in favor of the defendant housing provider, did not find that it was a discriminatory statement or showed any kind of preference or limitation based on disability for someone to say it's my policy not to accept dogs, even if service dogs. And this is, despite testimony from the landlord that he had added to his email communication the words, even if service dogs, specifically to respond to the fact that the application included a support dog. The court, in finding in the defendant's favor, didn't address an argument that the statement was discriminatory on its face, and didn't follow existing case law in how he utilized intent and context when assessing whether or not an ordinary person, an ordinary reader or listener would have found the statement to convey a preference, limitation, or discrimination. So an appeal is being considered in that case. The trial decision or judgment just came out on December 10th. So I may be reaching out to some of you for amici support on that one.
Michelle, I just want to give you a time note. You've been going about 15 minutes, so you may want to go a little faster to fit in Emily Rose after you.
Sure, the next ones they're not as long. The next case is Southwest Fair Housing Council versus WD Chandler Villas. This case involved a Fair Housing Council plaintiff that conducted some testing of housing for seniors to investigate willingness to accommodate deaf and hard hearing residents. The housing in question included a number of amenities, including safety checks by staff, where staff would ring somebody's doorbell and conduct a safety check. The housing provider informed the council's tester that residents had to pay for and install their own flashing doorbells. And ordinarily, modifications would be borne by the tenant, except in certain situations. Here, the court found that the flashing doorbell was not a modification that the tenant had to pay for, but rather it was a reasonable accommodation because it was linked to a good or service that the housing provider provides to all of its tenants, and it was something that the tenant had to have access to. Summary judgment was nevertheless denied in the case because there was some question of fact as to whether alternatives to a flashing doorbell were offered. But I did think that it was an interesting case because they were finding a physical modification or auxiliary aid to be the responsibility of the housing provider. That case, an interesting pleading issue to note that case also involved some Section 504 and Affordable Care Act claims that were based on the receipt of federal funding, and the court dismissed those claims because the plaintiff's complaint incorrectly stated that the source of the federal funding was Medicaid and Medicare, as opposed to specifying that it was veterans benefits. So the court found that that was a problem and that the defendant had no notice of the actual claim, that it was a new and different theory, so dismissed all the federal claims dependent on federal funding. Smith versus City of Oakland is an ongoing class action where the plaintiffs are alleging that the city's rent adjustment program uniquely excludes renters with disability in violation of the ADA and California law. That particular program contains an exemption for residential units that received a certificate of occupancy after January of 1983, which necessarily excludes a bulk of newly constructed and consequently accessible units. The city has been arguing on multiple occasions in this case that they're not liable as the result of overall inaccessible housing in the city, and claim that they're just regulating in a facially neutral way the inaccessible housing that currently exists. So the court has repeatedly rejected that argument, finding that it's the rent adjustment program's accessibility that matters, and that by choosing to regulate rent increases only on units that are not accessible, the city has allegedly denied plaintiffs meaningful access to that benefit of that program. And that case is ongoing. It's also a case that utilizes a disparate impact theory, which, as Claudia mentioned, is something that disability advocates are very concerned about getting gutted, with some cases that have recently been moving around. Most recently, the CVS Pharmacy versus Doe case that was up for review and was ultimately dropped because of pressure from the disability community. Roque versus Seattle Housing Authority, nice case where the plaintiffs' advocates obtained a TRO against a public housing authority, compelling them to accommodate a tenant by allowing his caregiver to use the parking space in the resident parking garage. The case had pretty good facts. The tenant required repositioning every 30 minutes, had significant health needs related to food and medication, and had no other option for someone to come and assist him. The reason the case was interesting to me is that these caregiver parking cases don't always turn out great, with courts finding that a caregiver's convenience is not something that a housing provider has to accommodate under the Fair Housing Act. There's cases like the United States versus California mobile home case that finds that way. The takeaway, I guess, is that the courts are requiring a pretty substantial showing that a caregiver's access to parking is necessary for the tenant's own use and enjoyment of their home. And here, there was really no alternative parking for the caregiver. The tenant's ability to get alternative care during the pandemic was limited, and the lack of care could have resulted in his death. Ramis versus Housing Authority of the City of LA, also a recent case, involves individuals participating in the Section 8 program who sought to have current household members designated as their live-in aides and were denied by HACLA. They filed a writ successfully challenging the practice. I would say if you haven't seen I only have a copy of the tentative decision, but the decision was pretty well reasoned. The court looked at the regulations that define live-in aid and also looked at some HUD materials in concluding that there's no per se ban on current household members being deemed live-in aids, and that really requests need to be considered on a case-by-case basis. And some considerations that may be some things that may be considered is, whether the individual is qualified, whether they were part of the household prior to receiving Section 8 program assistance, whether there's no other reason for the aid to reside in the unit, and whether the aid and the participant will maintain separate finances. The next two cases have to do with financial equity and accommodations. First is Dalia versus Wasatch Advantage Group. This involved a pro se plaintiff Social Security recipient who asked for a rental payment date farther into the month to accommodate the receipt of his benefit payments. And originally, after allowing him to do that, the defendant denied the accommodation. The plaintiff ended up being late 22 out of the next 38 months on his rent. He was served an unlawful detainer, entered into a pay and vacate stipulation. With regard to the payments on that stipulation, he asked for an accommodation 1 month of a couple of days. And again, the defendant denied that request. A writ of possession was issued against him. So he filed suit pro se, claiming violation of the section of the Fair Housing Act having to do with interference, coercion, and intimidation. He did not, interestingly, do a separate failure to accommodate claim. Nonetheless, a motion to dismiss filed by the housing provider was denied. The court found enough in the failure to accommodate allegations to support a claim of interference, and affirmatively noted that the Ninth Circuit has recognized similar types of financial accommodations, like in the Giebler case that was in an earlier slide. This case is worth noting because there's a relatively small amount of case law in this area. Finally, on this issue, Riley versus Marin Housing Authority. This is a case where the Supreme Court of California granted limited review of the question whether in-home support services payments should be excluded from annual income for purposes of calculating Section 8 payments, because there's a section that specifically says that amounts paid by a state agency to a family with a member who has a developmental disability, that can be an exception from calculating income. Upon review, the court held that money that the mother caregiver received from IHSS in this case was not income for purposes of calculating rent subsidy, and that excluding such payments was consistent with HUD's goals of discouraging institutionalization, expanding affordable housing, etc. The court also found that excluding IHSS payments would not create an unfair disparity based on disability type, because again, the regulation is limited to costs associated with caring for someone with a developmental disability. And because that disparity was inherent in the federal regulation itself, the court did not find that it was unfair when challenged. And finally, that money received from the IHSS program was not intended to replicate the wages and hours of a parent employed outside the home. It's a good decision to read. A footnote for people who are interested in financial equity cases. There's a case, People versus Cop, the citations at the bottom of the slide, having to do with whether a court must consider a criminal defendant's ability to pay before imposing or executing court user fees. It's fully briefed and pending, but it is of interest. A final case I wanted to review or go over is Green versus Mercy Housing, which has to do with the ability of a prevailing defendant to collect fees and costs. First case in the Ninth Circuit to deal with the issue. Panel held that a plaintiff bringing suit under the Fair Housing Act should not be assessed fees or costs unless the court determines that the plaintiff's claim is frivolous, unreasonable, or groundless, citing to Christiansburg, which is a commonly cited case on that issue. So that now the Ninth Circuit joins a couple of other circuits who've already applied that standard in the fair housing context. Two quick updates There's some new Fair Employment and Housing Act regulations going into effect January 2022. Among other things, it deals with discrimination based on source of income, reasonable modifications, which is a welcomed addition, discriminatory advertisements, and intentional discrimination. I provided a link to the regulations, and there's going to be some educational webinars in January, or beginning in January. You can sign up for alerts at the link at the bottom of the slide. And finally, DFEH also came out with a harassment prevention guide over the summer, which I don't know if people saw. It's for housing providers, but it's also useful for advocates and tenants who represent people who are experiencing harassment. The guide defines harassment, reviews legal obligations of housing providers, and provides guidance on how to deal with harassment claims. And there's a link, the guide is online, and there's a link at the bottom of the slide. That was all I had to say. Sorry, I went on too long.
This is Claudia. That was so great, Michelle. And no, you didn't go on too long. And now we're going to turn our presentation over to Emily Rose Johns, who's going to talk about her recent litigation on behalf of unhoused individuals in the East Bay.
Yeah, thank you very much. I'm really, I don't have any slides other than this one, but I'm really happy to be here. And that was really fascinating presentation about the Fair Housing Amendment. I have these two cases, Where Do We Go Berkeley versus Caltrans and Reed versus City of Emeryville, as a result of some years of litigation on behalf of people experiencing homelessness. And we had been pursuing constitutional claims for them. And we're running into various, various hurdles. The Constitution is a floor for people's rights. And we were looking for other ways to help courts understand and protect all of the rights of individuals experiencing homelessness. And we came to the Americans with Disabilities Act and Section 504 for a couple of reasons. I mean, one, many people who are experiencing homelessness have physical disabilities, but also we've been seeing more information about people experiencing homelessness having mental impairments that impact their ability to engage with homeless outreach services and to be both accommodated with accessible shelter option and accommodated with accessible housing option. These cases also came as a result of the pandemic, which did some very interesting things for people experiencing homelessness, including seeing kind of a astronomical amount of funds released from the federal government and from the state in California to help connect individuals who are experiencing homelessness with the housing options, shelter options. I think Claudia said she was going to talk a little bit about Project Room Key, which is one of the projects that was born out of that funding. And there was a large effort both to keep people experiencing homelessness in place in encampments, and then connect them with these programs like Project Room Key, Project Home Key. And so because of that, individuals in encampments were actually a little bit more stationary than they normally are, right? Not due to any conditions that they create, but because we see so many cities and so many states doing sweeps, of encampments on their property, kind of without regard for who they are or what they need. They provide what they believe is adequate notice. Sometimes they don't provide notice, and they come in and they tell people to move along, take what they can carry. And those, of course, have some implications for folks with mental impairments and physical impairments that affect their daily living. But these two cases are against two different agencies. They were in with two different judges in the Northern District, but really were about one encampment that spanned Caltrans land and City of Emeryville land. And the City of Emeryville case came first, and we filed a preliminary injunction that we lost. But our complaint was individuals can't be moved because the outreach services that have purportedly been provided to them are not accessible. And the single shelter option, which was a congregate shelter in the city of Oakland, which for those who aren't familiar is just south of Emeryville. It's not particularly far, but it is a different city with different access, different housing access. So Emeryville, I believe, is a part of the Berkeley and Albany kind of, I forget what it's called, entry point. And then Oakland is its own entry point for housing. So they were going to move individuals to a congregate shelter and a different housing entry point. And we tried to prevent the court, we went to court to try to prevent the city of Emeryville from being able to move folks without offering them an accessible alternative to the congregate shelter, arguing that the congregate shelter was not accessible to, this impacted 6 individuals at the end of the day, but 5 individuals had to move completely, 1 had to move over. And we said these 5 individuals have various mental trauma, PTSD, different psychological disorders that make it impossible for them to comply with rules in a congregate shelter or feel safe and get sleep in a congregate shelter. And therefore, what they're being offered, the only alternative, is not accessible to them. And a reasonable alternative would be to use the hotel vouchers that the city had as a part of their program for these individuals, rather than just for what they call their rapid rehousing project. And that they would use those hotel vouchers to bridge a gap until individuals could get into Project Room Key or a different connection with housing services. And the court denied the preliminary injunction. Our clients were ultimately displaced. There was an organization that put them into a hotel at its own expense, and they're now a plaintiff to recover those expenses, because this is not an organization that's mission and funding is to provide hotel rooms to individuals experiencing homelessness. But in order to stem the trauma that they were experiencing and to bridge the gap between them getting from the streets to the Project Room Key, I think is the project that they ultimately got into. In order to accomplish that, they had to pay for these hotel rooms, and that ultimately did get accomplished. Those 4 clients of the 5 who were displaced, 4 of them became our clients in that case, are now in the hotel rooms funded by the county, and it's slow going, but are being connected to more transitional or permanent housing. Those projects, as Claudia I think is gonna raise, we have issues with how accessible those are, including having curfews where if a person goes out at night because perhaps they need to in order to address their anxiety, or take their service animal out to go to the bathroom, they can't be let back in. And so that's some of the accessibility issues that we're seeing in those hotel programs that are run by the county and run by cities. But for our clients in the Reed case, it was a kind of ended the immediate crisis that we oftentimes see when we're representing individuals experiencing homelessness who are displaced. And it's allowing us to pursue changes to the City of Emeryville's program on sweeps and the accommodations that are required during those sweeps with respect to offering accessible shelter, that we're hoping can be a model for some larger cities. Emeryville is a relatively small city, but we're hopeful that this can help us educate Oakland and educate Berkeley and other cities that have a larger population of people experiencing homelessness than Emeryville. The judge just recently ruled on the defendant's motion to dismiss and is allowing us to proceed with our ADA claim. And the defendant's argument is that any modification that we're asking for is a fundamental modification, a fundamental alteration of their program. And so that's what we're going to be litigating, unless they want to settle with us and implement a more accessible program. At the same time, Caltrans went to remove, I say at the same time as a few weeks later, Caltrans decided that they were going to remove the remainder of the encampment that existed on its land. And it not only decided that it was going to remove that encampment, but it decided it was going to remove all of these encampments along the corridor of I-80 in Berkeley and Emeryville, which ultimately ended up displacing like 40 or 50 people. The individuals at the encampment right next to the encampment that was the subject of Reed filed a preliminary injunction. And that preliminary injunction got before Ed Chen in the Northern District, who is my new favorite human being on earth. And he issued a temporary restraining order and continued to issue temporary restraining orders based on changed circumstances. That temporary restraining order allowed us to get the individuals that were in that encampment connected with services. I say we, Lifelong Medical, did, I think, the large laboring or and Where Do We Go Berkeley, which is the organization we represent, as well as individual plaintiffs. So those individuals got inside, and then because that land was protected by the temporary restraining order, when Caltrans removed the other encampments along the I-80 corridor and displaced all of those individuals, they all moved to the land that was protected because of the temporary restraining order, and Caltrans created the same situation that we had just resolved by closing these encampments that should not have been closed by CDC guidelines, arguably should not have been closed by Caltrans guidelines. And
Emily, Rose, just a time check, if maybe a minute or two more.
Great. So that case is a larger case because it deals with the state. We have a preliminary injunction that we're defending in front of the Ninth Circuit. Caltrans, one of their biggest issues that's relevant to the ADA and Rehab Act is they are saying, we don't have a program. We're not a housing organization. We don't need to take care of anybody who's on our land. All we do is deal with encroachments, and encampments are encroachments on our land. But Caltrans did implement an interim guidance on removing encampments for people experiencing homelessness who reside on Caltrans land. In addition, the governor, and so that was the program that we've alleged is inaccessible because they're not giving people enough time. They're not giving accessible shelter options to individuals as a part of that program. The program specifically says that if they can't get people into shelter housing, they should offer alternative state land. And and Caltrans says, well, we're not actually going to do that. We actually won't do that. In the meantime, the governor in California told state agencies that they needed to assess what land they owned and report back on land that was suitable for temporary shelters. And some of the land that they had closed on the I-80 corridor was land that was designated by Caltrans itself as land that was suitable for a temporary homeless shelter. And so that's been another hook in our case, is that we argue that if they can't find actual accessible housing for individuals, and again, this is all based on mental impairments that preclude people from living in congregate shelter situations, not to mention COVID situation. If they can't find those accessible shelter options, part of the preliminary injunction said, fine, we'll open up the land that that Caltrans itself said was suitable for temporary homeless encampments. And Caltrans has so far refused to do that. So we're going to the Ninth Circuit. to defend our preliminary injunction. We just got an order yesterday on the motion to dismiss that's allowing us to proceed on our disability claims and our state created danger claims. And so we're very hopeful about the progress of that case as well, and how this is going to kind of give, I guess, teeth to the, I can't remember which case it was, Benucci, I think it was, that that you need to give individuals experiencing homelessness an offer of accessible shelter, before you move them, and you need to give them time to either get to that shelter, and that accessible shelter we're trying to impose with these cases has to take into account individuals' mental impairments. And I'll stop there so Claudia can talk about Project Room Key. Thank you.
Thank you, Emily Rose. That was really helpful. Erica, if we can have the slides back up. I'm not going to spend a lot of time on this on our next section because I'm going to let people ask questions. But what I'd like to say is that, we try to use the Constitution and Section 504 and the ADA to say that, the available housing is not accessible to people with disabilities. And, it's unconstitutional to force people out of their camps in order to, perfect, thank you, in order to, sweep the streets or whatever. But what I'd like to say is, despite all of this advocacy and work from, some of the most talented and creative lawyers that are around, the remedies that we are able to get remain very modest, yes, you can stay camping. The best case scenario is that we get people into one of the new COVID funded housing like Project Room Key or Project Home Key, and that's only because of this COVID money. In Glover, they tried to say the congregate shelter is not accessible, so therefore you need to create permanent supported housing that is accessible, and that was just batted away by the federal judge as being, well, I don't know if they actually said it was a fundamental alteration, but basically that was too great a reach. So this is where we are. It's incredibly important work, but so far the remedies have been modest, like you still get to camp. Anyway, in terms of the SIP hotels, Project Room Key, Project Home Key, this is all emerging because these are new programs. And so all of us who are in attendance at this training and all of the panelists, we are dealing with this in real time. And so some of the issues are, how do the rules of these programs intersect with people's disabilities? What about housing that is primarily designated for people with disabilities, such as people who are COVID vulnerable? Do those housing sites have more onerous rules? How are people being told about the right to reasonable accommodation, and what accommodations are being provided? Next slide. Next slide. Okay. Is there effective communication for people, particularly around plain language, or for people with sensory disabilities who are deaf or blind? Is there accessibility in terms of the intake process? Are the units physically accessible? What about a grievance process? Are the procedures for eviction accessible? And generally, we're finding no to all of these questions. Next slide. Angie, do you have a question for us? Does anyone else have a question? I can look at the ones that are in the Q&A. We've been answering them throughout. There's an issue about the DFEH that one of our attendees shared. I do know that with housing, oftentimes, a really quick solution is needed because of threats of eviction. And, DFEH tends to be a quite slow process. So I know that that's an issue. Michelle, do you have any, or Emily Rose, do you want to jump in on any of the topics that have been raise, oh, Dara has her hand up.
Hi, everyone. Dara Sure. DFEH tells me that they are willing to act promptly in eviction situations, but I think there are some challenges with the volume of cases they handle and the training of their staff who handle the first level of intake on these. So it doesn't happen very often, but there are California advocates working with them to improve their response on this issue and other issues. And might be worth going up the chain of command in DFEH if you're having trouble getting a response where you need a quick response. I do acknowledge that they're very overloaded. So they can be slow. They are, at the moment, they do have certain initiatives where they're targeting certain kinds of issues, such as discriminatory statements. And they are working on some new projects to do testing, in some situations and around some issues. So they are trying to become a little more responsive, but I acknowledge, but that certainly is a problem at DFEH. So I don't, I sit on the rulemaking body, the council, but I don't really have anything to do with the day-to-day operations. So I can just tell you what I've heard.
And then there's a question about Orange County's Project Room Key, what they're doing with their funds. I think that's an area where we're all kind of struggling, is trying to understand these new programs and where the funding is going and how everything's working. DREDA, for example, we're doing a series of Public Record Act requests on some Project Home Key programs. And I think that probably a number of us will be doing these kinds of PRAs for Project Room Key and Project Home Key. A lot of the Project Room Key funds are going away, but theoretically, Project Room Key beneficiaries should be given, services to another program, but, that's easier said than done in our reality. So I think we're going to wrap up. Emily Rose needs to leave. Michelle, any last words?
Sorry, it took me a minute to find the unmute button. No, I just want to thank everybody because I know it's right before the holidays and the new year and everybody's got a lot going on. So thanks for joining us today and take care.
And people can email us with further questions. I'm ccenter@dredf.org and I will put it in the chat. Thank you, everybody.
Thank you for joining us for today's webinar. This webinar was hosted by the Legal Aid Association of California, also known as LAC. We are the membership organization for California's civil legal aid nonprofits. Our job is to advocate in the legislature, in the courts, and with the State Bar of California on behalf of the community of nonprofits that serve low-income Californians. In addition to our online and in-person trainings, LAC provides coordination and advocacy for increased funding to support organizations like yours. Thank you.